Good morning, everyone. Thank you for joining our Q&A this morning. We're going to wait another couple moments to make sure everyone's in from the waiting room. And it looks like we're good to go. So we're going to start the Q&A with our normal Zoom housekeeping tips. You can find your mute and unmute and start and stop video buttons probably at the bottom of your screen. We ask that you keep the mute on so that background noise is minimized as much as possible. It makes it easier for everyone to hear. Please put your questions in the chat. We're likely to have time at the end of our prepared questions to take some off the cuff. So if you have a question that you didn't email to Chelsea earlier, please put it in the chat so we can hopefully get to it at the end of this session. Speaking about the chat, this Zoom is for general information. It is not legal advice. If you want legal advice, please contact your association attorney who can look at your documents, know your specific circumstances, and give you advice that is specific for you. Also, the chat is to ask questions or clarification. It's not for just general information or legal discussion like you see on the CAI message boards. And the last thing, really short today, is the Monday morning minutes. The Washington State chapter of CAI has a committee called the LAC, the Legal Action Committee, who works closely with the legislature regarding bills that are of interest to community associations. The LAC has a Monday morning minute where they will send a quick blurb on Mondays. This week it was on Tuesday because of the holiday, where to let people know what's going on with the legislature and let you know some bills that are of interest to the general community. This week was on the legislature looking at adding some more requirements to foreclosures. So the Monday morning minute is a good way to know what's happening with the legislature and the legislative session. They will also give a call to action if they would like managers or owners, residents of communities to contact your legislator and let them know how this particular bill may affect you, because without that information, the legislature doesn't know. So with that, Ken's going to give a brief talk on contracts. We've had some issues come up this week with particular clients, and since this is contract season, we thought it'd be a good idea to give a quick primer.
Good morning, everyone. So one of the things that I'll say surprises me frequently is the size of contracts which some boards will enter into with no review of the contract by either a consultant to help them understand that the scope is correct, or by an attorney to help make sure that the interests of the association are protected. And I get surprised that the clients are so willing to make massive down payments on construction projects before any work has been completed. So the contracts I'm talking about are not $20,000 and $30,000 contracts. These are often in excess of $1 million. And so part of what I want to do is discuss a little bit that, there are risks in entering into contracts, and you need to try and protect your interests. The cost of hiring a consultant to help you with the scope and to observe the work during the course of construction is modest compared to the overall price of the project and will reduce risk substantially for the association. The cost of an attorney to review the contract terms and make sure they are fair to you as a client is often less than 0.1% of the contract amount. And so I strongly recommend that you have that done instead of just signing a contract prepared by a contractor. So the two most important things in any contract relationship are to make sure that you have a common understanding of what work is going to be performed and what the cost of the work is going to be. And that's true whether it's a simple contract or if it's, a $1 million roof. And one of the ways to make sure you have a common understanding is to have a written scope of work. And we would often look to architects, engineers, or other building envelope consultants to prepare that scope of work. A scope of work that just says replace roof is not going to be good enough to have us come back after the fact and find a breach of contract if a problem is discovered. And so, sometimes a contractor will provide a scope of work with their bid, and sometimes they won't, but it's almost never going to include the level of detail that a consultant's specifications will. And if you're doing something which is, a high risk of failure, like a roof or a siding project, then I would strongly recommend you have some kinds of specifications. We really recommend against a contractor provided contract. It's going to be written to benefit the contractor. I looked at one last week, which basically gave the contractor the right to stop and walk off the job with 2 days' notice, but didn't give the owner any right to stop the job if the job was not going well or the association ran out of money. And it was great terms for the contractor. If he started to lose money on the job, he could just stop and walk away because it still required the association to pay him for all the work that he'd performed and pay him lost profit for the rest of the job. So it is important what these things say. On low dollar value contracts, it may be possible to patch together a contract addendum with the contractor's proposal to piece together a more complete and fair contract. But it's not quite the same as having one which is written by the American Institutes of Architects or prepared by a contractor for the association to make sure that you are protected. Some of the key things we want to look at are payment terms, at dispute resolution provisions, at insurance provisions. It's very important that you make sure your contractor has insurance and indemnification provisions so that if one of their employees is hurt on the job, that they don't sue the association. An employee is not allowed to sue their own employer in Washington state because of the way workers' compensation laws work here. The idea is that every employer is paying into a workers' comp system, and that is to protect the employees for injuries on the job. And in exchange, they are protected from lawsuits by their employees against them. But you, as the association, the customer of the contractor, do not get any protection from those kinds of lawsuits. And so if a person was working on scaffolding at your building and fell off the scaffolding and was injured, they can't sue their employer, but they can sue the association. And they'll do it just to try and find another deep pocket with insurance. So in terms of payment terms, our recommendation and the state of Washington's recommendation is only pay for work that you have gotten. And the state requires that every contractor put a specific notice on every proposal that says that the contractor has lien rights against you, that says that there is a bond with the state that is limited in its ability to protect you. In fact, the bond may be as small as $12,000. So if you're entering into a contract for $250,000 and you have a claim against that contractor, the $12,000 is not going to go very far to protect you. And that $12,000 is also there to protect every other customer of the contractor. We have had in the last year or so a contractor who did work for several of our clients declare bankruptcy. And all of the clients had signed contracts and made large down payments before the contractor went bankrupt. And basically, all of them just lost their money because the amounts were not so large that it was justifiable to spend the money in bankruptcy court to try and get a fractional share of what their debt was. And the contractor basically was able to walk away from most of it. So you do want to make sure that your contractors are licensed. Insurance is a big deal if you're a condominium, because many contractors have exclusions in their insurance policies for work on multifamily structures like condominiums. And so it's important to find out if it's excluded. So our recommendation, if you've got a project you're trying to get done this year, is get some help from a qualified person to write a scope of work, send that out to the contractors to give you bids rather than letting contractors design the work for you. Because if the contractors design it, you may get 3 or 4 different kinds of solutions, and you're trying to compare apples to oranges in terms of price and scope. We recommend that you get a contract. We prefer you write the contract to go out with a bid package instead of waiting to do it after the fact, because it'll make your process after you get bids much faster. We generally recommend you get multiple bids on larger projects. Some of your governing documents will require that anyway. We recommend that you get an attorney to review the contract, make sure there are not bad provisions in it for you. We do recognize that there are times you cannot get work performed without accepting risky provisions. Elevator replacements is one of the best examples I've got. There is such a tight market that the vendors can basically dictate terms which are very favorable to them. And you just don't have an option if you want to get your elevator fixed, but assume some of those unfavorable terms. And don't pay for work unless you've got product. So it's okay to pay frequently to make sure vendors can pay their employees. It's okay to pay for materials that are delivered to the job site. We don't recommend you pay for materials that someone promises you are in their warehouse, because we had claims last year where the client did pay for all the roofing material because the contractor had presented an invoice and promised that all the work was sitting, or all the material was sitting in their warehouse. And it turned out that all the material was in a warehouse. It's just still at the supplier's warehouse. And so the association paid for material that was never delivered. You also want to make sure that you're protecting your property against lien rights. It's really easy for subcontractors and material suppliers to lien your property if the contractor does not pay them. And it is a very effective tool at extracting money from associations. And you want to make sure that you're protected in those cases. So anything you want to add on contracts, Jennifer?
Just briefly, we discussed this last night about how a particular client already had a scope of work, already had bids, but had no financing to pay for a major project. So I just wanted to remind people that if you have, if you're considering a major project, do the bidding process and the loan process if you're looking at a loan at the same time. You can get a loan with just the information or less information than you think you need, but the loan process takes time. And if you have a contract that's ready to be signed, you're starting to look at financing, whether you're going to take from reserves or do a special assessment or get a loan, it's pretty much too late to have a review done quickly. Ken, am I butchering that?
Well, a loan process is likely to take 2 to 3 months. And just getting a ratification done for a project that you think you're ready to sign a contract on, if you have to do a budget ratification or special assessment ratification with your membership, and you're going to give them any time to pay before construction starts, you're probably looking at 60 days anyway. Certainly, you could get it done in 3 weeks if you're really well prepared, but most of our clients, we're looking at needing 2 to 3 months after they've got the bid to coordinate an actual full budget, which includes any kinds of contingencies and consultant fees or management company fees, and puts the number in front of the membership so that they can start collecting money. And normally I advise clients, don't sign a contract if you don't have all of the financing in place. And we do write in the contracts, we do a provision that allows a client to stop the project in the middle, basically terminate the contract if they can't get financing and funding. But we don't want our clients to have to exercise that. It's going to cause a whole lot of other problems. It just does save the association from being in default of or in breach of the construction contract if they are unable to have their owners pay the special assessments. But if you've got a project, we're happy to help. We help with the construction contracts. We help with the loan process. We help with the special assessment ratification process. We just would rather you do them concurrently if you know you're going to proceed than to try and do them one after the other.
It stops a huge scramble on our part trying to get you what you need in a timely manner when we should have had notice 3-4 weeks ago that you were in this
The
particular
other thing we did
project.
talk about last night, Jennifer, is make sure your membership knows that this is coming. We have too many clients who want to have closed meetings and talk about the project because they don't know exactly how much it will cost. They may know it's going to be $40,000 to $60,000 a unit, but they don't know exactly how much, so they don't tell their membership anything. And then when the notice of the special assessment comes out, they've got an enormously upset group of owners. So our recommendation is be open and transparent early. You should be advising owners that you're getting a project designed, and there's going to be some idea from your consultants and other people about what the cost is going to be, even early on. That should be reflected in your meeting minutes. All right, well, we've talked enough about that. We should move on to the questions submitted.
So our first question is, some associations have put a portion of the reserve funds into CDs or CODs. If the interest earned from these CDs is considered income, can that income be utilized as a payback to reserves for borrowed funds? So the answer is yes. The income can be added to your reserve distribution and put back into reserves to help mitigate either borrowing or reduce reserve distribution to owners. So assessments either stay the same or are less, have a smaller increase than what may have been. But you're also maybe getting into a and I'm losing the reference, take from Peter to pay Paul. So be careful on how you do that. It is an income stream that can go into reserves. It's just make sure that you're allocating enough of a distribution to your reserves to cover the borrowing, as well as keep up with your reserve contributions so that you're not deficient. Ken, did you have anything to add to that?
Well, when I see questions like this, I sort of feel like people are playing games, trying to avoid funding reserves. And whether you're calling the interest income, operating income, or reserve income, I don't think really matters. Whether you're calling it a contribution to reserves or a repayment of reserves you borrowed from, at the end of the day, you're still not going to have enough money in your reserves to pay for your future expenses. And so your CPA is going to be able to advise you some. We've already answered before that we think all income from every source starts as income at the top of your uh, income statement. It only becomes reserves when you transfer it into reserves. And whether you're transferring it because it's interest income or because it is part of your uh, monthly assessments, it doesn't really matter. It's just still transferring to reserves. But it doesn't make you well-funded. It may comply with some particular statutory requirement, won't make you well-funded. Question 2. Our association is planning to increase our master insurance deductible from $5,000 to $25,000. Does the association need to send notices and require read receipts and request a copy of the owner's insurance policy to make sure everyone received the change notice and has adequate coverage to meet the increase? So this will depend entirely on your particular association's governing documents. If you don't have the ability to assess the deductible to owners anyway, which is true for most condominiums, then no owner cares and doesn't have to change anything with their policies related to the property damage for the building. If you do have the ability to assess the deductible back to the individual owners, whether it's for damage to their unit or damage they cause, then I would say absolutely you have to inform the owners that the deductible has changed so they have an opportunity to purchase the correct insurance. And whether you do that with an email or with a notice as provided for in the statute is dependent on whether an owner has agreed to accept electronic notice. Whether you get a read receipt or a green card back from an owner to prove that you sent them the notice, I suppose that's up to you and depends how much you want to make sure owners are informed. If it's a big increase, like from 5 to 25,000, then I would suggest, yes, it's worth trying to get a confirmation from your owners. Some governing documents give the board the right to require certificates of insurance from owners. And so you can exercise that right and collect certificates of insurance. I suppose you could even assess fines to people who don't produce it. But on the other hand, whether they have insurance or not does not change their obligation to pay the deductible under the association's policy. Whether they have to do that or not is a function of the declaration, not a function of their insurance policy. The other thing I would mention is that if you increase your deductible to 25,000, even if you're not able to transfer it to individual owners, I would want to make sure that your budget and your resources, meaning bank accounts, have enough money to pay the deductible. Because a lot of claims are for common elements. If you have a tree fall on the building or a fire, you're likely to have common elements where the deductible is still paid by the association. And you need to make sure that you have money in the bank to pay for it. Some associations actually have insurance reserve accounts, the same as they have a maintenance reserve account. And so that is a place that could collect funds to pay for the insurance deductible. But it is something you need to make sure you're sort of budgeting for. And it'd be great if you get through a year and don't have to use it, but it's really painful if you do not have the resources and an event occurs and you have to seek additional money from the owners in order to cover the obligation of the association. Anything you want to add, Jennifer?
Just briefly, and this is more general than, excuse me, just informing owners regarding insurance. The statutory requirement for notice is that the board sends notice correctly. You are not required to prove that an owner read it or even received it. So if you have to send someone notice, according to the statutes state that the notice is effective as of when it's dropped in the mail or as of when the email was sent, if they've opted into receiving electronic notice. You don't have to prove that someone actually opened the letter or read the email. Did
You
you
have to
have,
be able to prove you sent it, though.
yes. Did you have anything else to add?
No.
Okay, so next question. Looking towards Ukiah in 2028, I'm concerned about the potential financial impacts of 6490 for 7072, which I interpret as requiring the association to maintain property insurance on all the townhouses with common vertical walls. However, it also says unless provided otherwise in the declaration. Does that allow the declaration to dictate the vertical common wall insurance requirements? So we can't specifically answer this question because the answer really depends on the language in your governing documents. But in general, the answer is no. The unless provided otherwise clause refers to the improvements and betterments, and this is all regarding insurance required for units. So, Chelsea, could you put the language of that particular statute in the chat? I was going to do that and then I forgot. So, this particular statute is regarding what insurance is required on the units, and 6490 refers to lots and units interchangeably as units. So the association's required to insure the unit, but is not required to insure betterments and improvements unless the declaration specifies. So the answer to this question about the vertical walls really depends on how the boundary of the unit is defined in your governing documents. So it's unclear whether a party wall in a townhome community is a common wall between units. So traditionally, party wall is not considered to be a common wall. The property line divides the wall, each half belonging to one of the units. The legislative intent isn't clear in this particular statute, so we don't know unless and until either the legislature revisits the statute, and we don't know that they're going to this legislative session, or unless somebody brings a lawsuit to court and there's a court case that we can refer to. The low risk option would be to have the association buy insurance. So it's also unclear if a townhome community has structure inside the wall boundaries, whether the requirements to insure the unit includes a structure, if the document may provide otherwise. You could purchase insurance that includes the units but no improvements within the units, which would be like not having insurance at all. So if you want an analysis on what insurance is required from your for your association, please contact your association's attorney who can look at the makeup of your particular association, look at the governing documents, and give you an informed opinion. Ken, did you have anything to add to that?
Well, I think it is possible for an association to amend their insurance provision, whether they're a townhouse community of, plat community, or whether they're a condominium, to clarify whether or not the association is going to insure the structures in the unit. And part of that would be to define in your specific documents what common wall means. A common wall is not defined in the statute. A common element is defined in the statute, but a party wall between townhouses is not a common element because it is not owned in common by the community members. So if you want a particular outcome, meaning if you want owners to buy insurance for their townhouses, then it is, I think, possible to write a clear insurance section for your community that states that owners will insure the structures in their lot and that the association will not. But it creates some uncertainty if you are not revising your documents to comply strictly with the language of the new statute. Anything else, Jennifer?
No.
Okay, next question. Our articles of incorporation have some general statements like directors shall be elected for a one-year term by vote of the members. And if a director shall die, resign, or be removed, the remaining directors shall be responsible for replacing that director. Our bylaws spell out in detail the processes for our annual elections, removals, and replacing directors. Our new board is saying that because the articles take priority over the bylaws, they don't have to follow the processes spelled out in the bylaws. Other people are saying the bylaws are supposed to spell out the details. Can you explain? So I'll say the short answer is that if there's a statutory provision that states how your elections or directors are to be handled, that has the highest priority. The articles of incorporation are ahead of the bylaws, but most articles of incorporation will be very vague and will say something like board members shall be elected as provided in the bylaws. So if your articles do have something specific like the board, that shall be a board of 3 with 1-year terms, then I think you do that even if the bylaws are different. And if the bylaws are, excuse me, if the articles are silent on an issue and the bylaws say something, then you follow the bylaws. Usually we see bylaws being much more specific. There are many associations where no one has seen a set of actually filed articles of incorporation with the Secretary of State. Now, there are some times that they do exist, and you can ask the Secretary of State for a fee of, I think, about $50 to send a copy of all the records that they have. Articles can be amended, so if you believe that there is a problem with the way it's written or some confusion, you can certainly amend the articles as they're provided for. You can amend the bylaws. And you also have to make sure you're checking your declaration, because I think the statutes say that if there's a conflict between the declarations requirements for the board of directors and your articles of incorporation, the declaration is going to control over the articles of incorporation. Maybe you remember if that's the case, Jennifer.
I believe that is the case. And also, if you are incorporated with the Secretary of State, more likely than not, you can check your listing and find a copy of the filed articles. I've been working with a community that was incorporated in 1966. And while all of their yearly updates aren't on the Secretary of State website, quite a few of them from the 60s and 70s are. So if you have a question about your articles or want to get a copy of them to just view, go on the Secretary of State's website. It will likely be there. And moving on to the next question. So this is from a manager. This manager has often worked with associations that have a lot of rentals, usually a 6-month minimum term, rental term versus short term. Common issues were that tenants would change, but no one reported it to the management company or the board, or tenants provided the association management company as their individual property manager rather than the owner or the actual property manager in charge of that particular unit. So the question, with that background, the question is an association overreaching by developing a rental policy which must be reviewed with the manager or board liaison and the unit owner or property manager, that highlights the responsibility of the units to the tenants and the association, and then sign a document acknowledging that they understand the responsibilities of renting their units. So again, this answer really depends on what you're trying to do and what the language of your particular governing documents are. As long as there is underlying authority in the declaration for whatever rules you're wanting to enact or the policy, the board can enact such a policy. However, we have run into situations where this has happened, but requiring an owner or property manager to review the policy with a board member or the association's manager probably isn't enforceable. We do have some clients that have provided an approved lease that owners can use. We don't know that you can really require it, but you can have an approved lease available for owners to use as a courtesy or to make a shortcut, so you know those particular issues are covered. So you can also use the association's enforcement procedures on owners who violate a policy that could be enforceable depending on the language and how you go about doing that. But any new restrictions on how owners rent are best adopted in the declaration. It may depend on what you're trying to regulate and what your current documents state. So the next part of this question is it possible associations would need to amend their declaration to allow such a rental policy to be enforceable? As we've said, it really depends on what you're trying to do and what your documents already state. And before you do this, please contact your association's attorney who can guide you through this process and let you know what you can and can't do regarding what's currently in your documents and whether you need an amendment. We've run into too many issues where associations either think they have the authority or just do, without even thinking about it, enact a rental policy, and there's no underlying authority for it in their governing documents, which means it's unenforceable. When that's challenged in court, the association is going to be liable. Ken, did you have anything to add to that?
Well, we haven't had a Washington state case really looking at the limits of what an association can do to control rentals. There have been cases in other states where associations have required that every landlord use the same property management company or use the association's management company to handle all of their individual unit rentals. And I think the other states have ruled that it was okay for the governing documents to put that kind of requirement in place. And it was, challenged by individual owners who didn't want to pay the management company fees for their renting their individual lot or owner. And the courts basically said, well, it was in the governing documents, so it was okay for the association to have that requirement. But again, it has to be within your governing documents to create that obligation for the property owners. Next question. Could you talk a little about how to handle when owners threaten to sue the board? What is the best way to respond? What are the chances an owner will actually sue? What liability might the board have if they're handling things reasonably and proactively? What if they're too slow on certain issues, and what if things change? Well, of course, everything depends. The first comment is that we see owners threaten to sue board members frequently. And I would say most of the time they are idle threats. No one follows through. And sometimes they don't follow through because they work something out with their boards. And sometimes they don't follow through because they go see an attorney and the attorney tells them they have no legal rights. And sometimes they just look at the cost and aren't willing to spend the money. But I would say, the first thing I would suggest is that you listen and try and understand what it is the owner is complaining about, or why they're threatening to sue, and what legal arguments they're actually making, and make sure that the actions of the board are reasonable and comply with the governing documents for the community. So if the association is refusing to fix something and has the obligation to fix it, and an owner threatens to sue because it's not being fixed, then the answer is probably the association should fix it in order to avoid being sued. But without knowing the specific facts and circumstances, you cannot evaluate any particular situation. If you have a credible threat about a lawsuit, then you might want to talk to your attorney to see if there is any kind of actual response you should have or change in how the board should respond. If it's a letter from a lawyer to the association threatening to sue, that might actually be circumstances under which you should inform your insurance company that a claim is being made against the association. Depending on the kind of claim being made, it might be covered by either your general liability insurance or by directors and officers liability insurance. And one of the key things that you buy insurance for is so the insurance company will pay a lawyer to defend you, because the lawyer fees can get really substantial in some cases. And so you can send a copy of a credible threat to your insurance agent and get the agent's advice on whether or not that should be filed as a claim. Sending a notice of circumstances that could lead to a claim is different than filing a claim. And it's the sort of thing, if you had a slip and fall, you want to notify your insurance company right away because they may want to manage that injury in order to minimize the potential for a claim later on. That's why you actually have in most policies for general liability a little provision that talks about, you know, $5,000 for medical treatment for each person who's injured. And that is specifically to try and make money easily available for the treatment of a person who's injured so it doesn't grow into a more expensive claim later. You know, one of the things we do recommend is that if an owner is threatening, that you respond to the owner and let them know that you've received their message or their threat, and that you will be looking into it and making sure you respond appropriately. I think you need to look at the governing documents for the individual community. Many times there are specific dispute resolution provisions written into the documents. And they may have been intended to help the developer when the developer was first selling out the community, but they often are still required to be followed by either the owner or the association in terms of resolving a dispute between the members. And sometimes those will have an alternate dispute resolution process, mediation, or something like that, which may actually help you resolve a potential dispute. One of the things that we as attorneys would try and make sure you're doing is meeting your duty of care in how you are responding to any issue with an owner who might be threatening. So there is a duty of care, which under the statutes is essentially exercising reasonable and ordinary care. That's how it's phrased, I think, in the Condo Act. Exercising care as a prudent person in a similar situation would is sort of the shorthand of what's in the Nonprofit Corporation Act. And it basically boils down to making sure that you are having adequate inquiry with objective information. And those are the standards which are now written into Ukiah, and they were established by the Riss v. Angel case here in Washington State. So you want to make sure that you are responding, communicating, because one of the things that's most likely to make an owner try and hire an attorney or sue is not getting a response. So you also asked about what if the board's acting too slow, or what if things change? Well, acting too slow might actually resolve disputes for you, but not in the way you want. There are many CC&Rs and fewer condo declarations, which will have some kinds of issues resolved by the passage of time. So if there's an ACC request and the board doesn't respond within 30 days, it may automatically have been approved. And so the board no longer would have the authority to challenge a request by an owner. So if the litigation involves something that's already being handled in your governing documents, you need to know and act accordingly. And the passage of time may be relevant to reasonableness. Okay. So how fast the board responds is really going to depend on the issues involved, the circumstances. We have a lot of owners who will make demands, or their attorneys will make demands that boards do something within 7 days. And it is not possible for a board to comply with the requirements of the statutes for conducting their business at meetings, and those meetings be open, and that membership has notice of those meetings, and also take care of something for an owner within 7 days. It just can't be done. So sometimes it's a matter of talking with the attorney or the owner involved, not to do it within the time they're demanding, but if you can explain the time process and why it is as long as it is, that may actually go a long way towards, I'll say, meeting the reasonableness requirement that the board has. And it is also, I would say, true that, disputes or issues which have gone on for a long time are, often, they become okay just by default or acquiescence by owners. So anything you want to add, Jennifer?
No. Moving on. We feel harassed by a tenant whose mother owns a condo. The individual is bipolar and schizophrenic, and something happened between him and a homeowner, but nothing was told to the rest of us. Just a neighbor mentioned it to us because he talks to her. Can management, the association, help us, or police should be involved? Whatever we do, he is there at all hours. He has been trying to interact with us, and we want nothing to do with him. Garbage, recycle, mail, storage unit. He is always around, and coincidentally, he is out and about every time. So this question is too specific for us to give any advice, legal advice, or even practical advice. The issue is that annoying behavior isn't always actionable. So the association is limited by statute in the governing documents to sending warning letters and levying fines for violation of the governing documents. So someone just hanging around and trying to talk to somebody isn't necessarily a violation of the governing documents. So individual owners have more authority than the association to deal with interpersonal contacts or conflicts. Have you talked with the owner of the unit, the mother, to see if she has any strategies or can help you? Is one way to start dealing with this particular issue. You can try to file a police report and start history for an anti-harassment order, but courts have a very specific set of guidelines to find illegal harassment, and it may not be the same as what you think. Most cases, the association will have little or no power, especially if the individual's activities are not clear violations of the governing documents. So the association has a duty to act reasonably and treat similar situations similarly. So if everyone has a problem with an individual person, but what he's doing isn't necessarily a clear violation, the board or association can't start the enforcement process just because this person is driving everybody batty. Some communities will adopt anti-harassment policies, which may give some ability to find a violation, but this particular issue has too many moving parts, and you really need to speak with either an association attorney or a personal attorney to find out what you can and can't do. Ken, did you have anything to add to that?
Well, just that, one of the sort of unfortunate aspects of community living is that you cannot regulate who is in your community, and um, you not cannot get enforcement because of protections which our government system creates, and it does make it very challenging. So if you've got something that really is a problem, we generally would recommend you see what you can get in the way of assistance from an attorney, or try and get help through social service agencies, um, or through family members. I would lean on the mother if it were me. Next question. We have a frequent visitor to the building who vandalizes our property and steals parcels. We've watched this on surveillance video many times. His mother and owner lets him in the building, so technically he's a guest. We frequently file police reports for his behavior. The police say thanks and give us an incident number, but that's as far as it goes. The required repairs have cost us plenty. Since Amazon will replace most anything, no questions asked, the recipients don't bother to file complaints. Is there anything we can do to keep them out of the building and off the property? So the challenge is that every owner's got the right to invite individuals onto the common property, and the association cannot prohibit a person entering the property. This is sometimes called, you cannot trespass them, because it is possible to write a letter to an individual person to keep them off your property. It's just that your property is collectively owned, and unless the individual owner who is involved was willing to sign that trespass letter, you couldn't do it against this person. Um, Depending on the language of your particular governing documents, you may be able to hold the owner responsible for the misconduct of this individual, and that may be something which would put some pressure on them to try and solve the problem. But you're going to need to look closely at your documents. The statutes are really unclear. The Condominium Act and Ukiah talk about misconduct some, but then misconduct is not defined. And if you were to look at the newest version of Ukiah, which was amended last year, it now says that to use the misconduct provision, you have to have defined the particular behavior as misconduct. Or to assess the cost to an owner, you have to have specified in the documents what the costs are. You can't make it up as you go. So you may need some help interpreting that from an attorney. But you can look at your enforcement procedures. You can look at having specific rules and fines that might relate to allowing people into the building that are causing damage or committing theft. And if you're going to try and build any kind of case against the owner for the conduct of the guest, you're going to have good documentation and evidence to support that the guest is actually the one committing these offenses. That's because almost certainly the person who let them in is going to deny that their family member or friend is actually the person doing these bad things. The other thing we'll offer is that we have had a couple of clients who have installed secure package lockers in order to allow for security and limit the theft. We had a client of about 100 and, I don't know, 130, 150 units that was having a lot of problems with packages being stolen that were being left by the mailboxes because they didn't fit in mailboxes. And they did install a set of lockers so that the packages could be secure while they were waiting for the owners to pick them up. And it might be that you can do more with that. Anything you want to add, Jennifer?
No, and this is our last question that we've prepared, so we may have time for one or two questions. Please feel free to put them in the chat. So the question is, does the board need to provide 30 days notice for monthly meetings for the owners to join? So there's a difference between board meetings and association or owner meetings. There is no requirement under the current condominium statute 6432, 6434 to give notice of board meetings. but your particular documents may have an open meeting requirement. So in 6490, the statute is 6490-445 sub 2 sub F. And it states, unless part of a schedule previously published to the owners, notice of board meetings is no less than 14 nor more than 50 days. So if you're a 6438 community, there is no, you're required to have open meetings, but the timeline isn't specified. We recommend defaulting to the no less than 14 nor more than 50. 6490 communities, that particular statute applies to you. One thing for individuals to know is that the legislature is really looking at the meeting statutes this legislative session. There is a part of a bill in front of them that deals with this, and open meetings and the meeting requirements may become applicable to everyone starting as early as January 1st of 2026. So in other states, other courts have held that failure to notify owners of a board meeting is a violation of the open meeting requirement. And honestly, in this particular instance, bad facts make bad law. If you're required to have open meetings but aren't providing notice to owners, you're not giving them the opportunity to attend, and please don't do that, because we don't want to try to go to court on that particular set of facts. Now, it wouldn't be a bad idea, even if you aren't currently subject to open meeting requirements, to start complying with the requirements under 6490, just so that you're getting used to it and will have no problems when it comes into effect starting January 1st, 2028, or if the legislation passes January 1st of 2026. Ken, did you have anything to add to that?
No, I'm good.
Okay. Chelsea, do we have questions in the chat?
Yes. If there's time, could you briefly review the statute requirements for holding an open board meetings for condominiums governed by 6434? Is this one of the provisions that will change in, they say 2026, but I think they mean 2028?
Well, we just answered that. There are no requirements for open meetings in the condominium statutes. You will be required to comply with all of the open meeting requirements in Ukiah as soon as it is taking effect. And that is likely to be now 2026, but the current statute says 2028.
Okay. If a client would like a general 11-month proxy for all meetings instead of a proxy for each meeting, should we provide general proxy options?
So the way the proxy statute is written is that it is expiring after 11 months unless it says something different. So an owner could give a proxy to their neighbor with a period of 2 years if it stated 2 years, or it could be for 1 month if it stated 1 month. Most clients we see prepare proxies, prepare them with a limited time frame, such as just for the meeting, if they're sending the proxy out. But there's no reason that either the association or individuals could not write proxies for any period of time. The statute says it's from 11 months from the date of the proxy, if it is not otherwise indicated.
And one thing that we emphasize to our clients is that you're not required to give a proxy. As if an owner has a proxy once or draws up a proxy to give to someone else, you need to verify that that proxy is valid and complies with statutory requirements. But the association isn't required to draft a proxy for the owners.
But if you're trying to get more votes, proxies are a way to do it.
Yeah.
Got another one, Chelsea? We'll do one more.
We are a non-Wakaiowa HOA with private streets. A vehicle that has been parked on our street for at least a week has been found to be totaled in June, but not reported stolen. Does the HOA have the right to tow? Other options?
Well, it's starting to get really specific, and without seeing your governing documents, there's no way for us to know if you have the right to tow.
And just because you have private streets doesn't necessarily mean that statute doesn't apply. So you can call the police department and ask them to tag the vehicle and have it towed. It's up to them whether they do it.
All right. Well, I think we're done for the day. Thank you, everybody, for attending, and we'll see people next week.